I'm Kay Sumner, here to introduce to you the Newport News Juvenile Domestic and Relations District Court. The JDR is located here at 2501 Huntington Avenue in Newport News
and is open Monday through Friday from 8 a.m. to 3:30 p.m.
Parking is available along Huntington Avenue and in the city parking lot for $3. Pay close attention to all parking signs to ensure that your car is not towed. All cases are expected to start on time. The court may hold you in contempt if you are late or if you fail to appear. The courts take precautions to make sure that everyone is safe and to ensure that there are no disturbances. All parties will step through a metal detector. Certain items are not permitted. Proper courtroom etiquette is expected, and there is a dress code that will be provided to you. You must be polite and respectful at all times. During your case, speak only when it is your turn and always in a quiet voice. You will need a lawyer. You may hire one or ask the court to appoint one for you. Always be sure that the court, the Department of Human Services, your lawyer, the guardian ad litem, and CASA have your current number and your physical and mailing address. Parents receive the following information from the court: dress code, handbook for parents and guardians in child dependency cases, foster care timeline, contact information for their lawyer and child's guardian ad litem, letter explaining the role of CASA. At the end of each hearing, you'll receive a copy of the court order and be asked to sign a promise to appear at the next hearing. Please keep these. The judge must make all decisions based on the best interest of the child. Parents and other relatives are always secondary. The child's Department of Human Services worker and guardian ad litem also helps the court decide what is in the child's best interest. The court is required to review the case at regular intervals to ensure proper planning for the child's permanent placement in a safe home. Strict guidelines established by federal and state law mandate the frequency of these hearings. The foster child is encouraged to attend these hearings to give feedback to the judge. Biological and foster parents also receive notice of the hearings. Now, here's Judge Barry Logston to explain the foster care hearing process.
First of all, foster care, the most significant way that children come in is through a finding of abuse and neglect by the court. How does that happen? So a finding of abuse and neglect comes when the court makes a decision after a petition is filed that a child has in some way suffered as a result of a non-accidental physical or mental injury that is given by a caregiver, a parent or a guardian who is responsible for the care of a child. Or they may have neglected or refused to provide adequate food, clothing, shelter, or emotional nurture, or health care for a child that they're responsible for. A parent that abandons a child, or fails to provide adequate supervision for a child, or commits or permits to be committed any illegal sexual abuse on a child, allowing a child to be under the care and supervision of a registered sex offender. All of these would be abuse and neglect under Virginia law. How can a child come into the foster care system? There are other ways. There is that finding of abuse and neglect. There's also when a petition is filed by someone who's responsible for a child and they say, I need to be relieved of custody. Another way that a child can come into care is on another matter that is already pending before the court, such as a delinquency case where a child is charged with a crime, or in a case where they are in need of services or in need of supervision, and in the middle of that hearing the court decides that return to the parent is not appropriate. So the court can actually give custody to the Department of Human Services in any of those cases, even though there was no original request for the court to do so. Today we're looking at civil abuse and neglect, which is whether the child is in a condition that needs to be removed and placed with someone else, regardless of whether someone needs to be punished. So today, in civil abuse and neglect, this is how it happens in Virginia. Someone would have to file a petition with the court, that is generally the Department of Human Services, and they ask for an emergency removal order immediately upon realizing that this child is in severe crisis. In fact, they actually have to allege, and the court would have to find, that the child is in imminent danger and that the danger cannot be fixed, what's called irremediable injury to a child. If the court does make that finding at an emergency removal order hearing, where generally parents are not present, normally there's only a Department of Human Services worker and the city attorney in the court, and an affidavit or testimony is presented to the judge to say this child was in great danger, and specifically those kinds of danger just mentioned, and then the court would make a decision immediately as to whether that was the proper thing to do. If the court makes that emergency removal order finding, that hearing is called a preliminary removal hearing. And at that hearing, you would have an attorney as a parent. The court would appoint you an attorney at that very first emergency removal hearing. The attorney would contact you, and you would be invited to be present. If you are present and your attorney is present, the court may actually make a finding of abuse and neglect on that day unless one of the attorneys objects. In any case, whether the decision for abuse and neglect is made, there must be a dispositional hearing.
Dispositional hearing. When the court decides upon the plan, the parties will follow until resolution or reunification.
Foster care sets forth various goals that the agency, the Department of Human Services, must work toward. Those goals are for the parent, as well as for the child and the agency itself. So mostly what we look at are these goals: return to own home, relative placement, and adoption. Time is always of the essence in these matters, and federal guidelines require state courts to operate within very tight time frames to accomplish permanency for children. When a parent is not able to remedy the situation that put the child into foster care within the time frame scheduled by the court, then the court will move on to other options, and return to own home may not be the option considered by the court. So placement with relatives is generally the second option that the court considers in placing a child. What family members would be appropriate to take care of this child so that the child has the most family-like setting and is most connected to their family of origin as possible? Because of the seriousness of these findings and the need for a child to be placed with a family member, it's important that parents immediately divulge to the court possible relatives who would stand in the place of them if the court removes the child from them permanently. If there are no relatives to be considered, then the court can place a child outside of the family. If the court is going to consider adoption, a termination of parental rights petition must be filed by the Department of Human Services right away, so that everyone is on notice that we are going to move towards adoption and the rights of these parents will be terminated so that the child will be free for adoption within a reasonable period of time. At any stage of the proceedings where the court has made a final order, there is always a right to appeal to the circuit court within 10 days. At any time that the court has entered a permanent goal, meaning within a 6-month goal, that can be appealed. A termination of parental rights can be appealed within 10 days. If those time frames are limited, make sure you communicate with your attorney about your appeal rights. I'd like you to meet other participants in the foster care process. And the next participant that you're going to meet is Patsy Ewell, the head clerk for the Juvenile and Domestic Relations Court.
Hello, my name is Patsy A. Ewell, and I'm the clerk for the Juvenile and Domestic Relations District Court for the City of Newport News. The Juvenile Court Clerk's offices are responsible for processing service plans that are filed by the Department of Human Services regarding children that have been removed from their homes. These service plans have to be filed within a timeline, and once they are filed with the clerk's office, our responsibility is to, 1, process them into the computer system, assign to the case number, notify all parties, that includes the foster parent, the foster child, Department of Social Services, guardian ad litem, any attorneys for the parents, as well as the mother and the father of the child. All parties have to be notified that there is a hearing scheduled before the court. Once that's completed and the process is done as far as the court process, then the clerk's office is responsible for certifying court orders that are issued by the judge involving these children, and then we are responsible for getting those out to all the parties. The law does require that any person with an intent to move or relocate must notify the other party as well as the court of their intention to relocate. The purpose of that, as far as notifying the court, is so that we can send notice to you. We can notify you of any upcoming events that may be taking place in the court. It could be detrimental to you, to your case, You could be assessed fines and costs and not be aware of it because we have not been able to notify you of that. By you not being notified of that, you haven't paid it, your license can be suspended, and numerous of things could occur. The clerks of the court are prohibited from offering legal advice. The clerk's office can only advise you of what the court order states. If the court order says visitation every other weekend, then that's what we would iterate to you, is that there is a visitation order in place. And with that, you're also not allowed to contact the judge to ask the judge what you should do in a circumstance. A judge is only permitted to discuss your case with you in open court where all parties are present so that the other side can hear what you're asking, the other side can hear what the judge is saying. Whatever you need from us, whatever assistance, whatever you need to help your court process work a little smoother, that's what our sole purpose is. My office is a very customer service oriented staff. They believe in customer comes first, and that's what we do. We know that it's a process that can be very troublesome, it can be very intimidating, but when you know that you have a staff of people, such as I do, that are willing and eager to put their best foot forward to make sure that your experience here in the court is not one that is detrimental to you or any member of your family. That's what we're here for. Our office is here to serve you, and those hours of service are 8 a.m. to 3:30 p.m. Monday through Friday.
I'm Patrick Murphy, Assistant City Attorney. The Office of the City Attorney is the legal advisor for all the departments within the City of Newport News, including the Department of Human Services, or DHS. DHS is comprised of a variety of units that provide resources to families in need. These include Child Protective Services, Family Stabilization, Structured Family Therapy, Foster Care, Adoption, and Children in Need of Services and/or Supervision, also called CHINS. It is our role, in and out of the courtroom, to ensure that the proper legal processes and procedures are followed, to advocate and advise the Department of Human Services, all with the goal that the best interests of the child are being put first.
I'm Heather Davis with the Newport News Department of Human Services. When a child enters the foster care system, it is our job to ensure that the best interest of the child drives every decision that's made.
The best interest of the child. The best interest of the child is defined in Virginia Department of Social Services policy as the physical safety, including food, shelter, health, clothing, and emotional well-being of the child. It also recognizes the child's need for a permanent home and continuing relationships with parents, siblings, and other relatives.
Because everyone's situation is different, services to each family may vary. We are a team working together to achieve permanency for children in foster care, so it's very important that you keep the lines of communications open with your social worker. Your social worker needs any changes of address, employment, telephone number, as well as your progress in completing recommended services. Likewise, the agency will communicate what is going on with your child and the goal the agency is working towards. You may request a family partnership meeting for your support systems and your social worker, their supervisor, and any other parties you feel are important in developing plans for your family. DHS provides many services including parenting, anger management, GED classes, and other education, mental health, alcohol, and substance abuse counseling, financial and budget counseling, plus help in finding work and housing. Often ordered by the judge, these services assist in having your child return to a safe environment. If you fail to participate, your parental rights could be terminated. As a core principle, Human Services believes all children do best when placed in families. The clock is ticking to complete services and show progress to both Human Services and the courts to achieve a positive outcome. While it may seem overwhelming, there are support systems such as the Department of Human Services, CASA, and others that can help you through this process.
My name is Cheney Riley, and I serve as a guardian ad litem in the legal court system. And as a guardian ad litem, I advise and inform children of their legal proceedings, their rights, and my role as a guardian ad litem and possible consequences for legal actions.
The guardian ad litem, or GAL. The guardian ad litem, sometimes called the GAL or guardian, is an attorney appointed by the court. With specialized training, they represent the best interests of the child throughout the court proceedings. The GAL advocates only for the child.
Once a GAL is appointed, the parents need to contact the GAL promptly and inform them of their position and maintain contact throughout the proceedings. Parents should provide contact information for themselves and anyone who might be helpful to the case, such as relatives, friends, neighbors, etc. The GAL will want to visit the child's home and the home of any relatives who are being considered for possible placement. If necessary, the GAL will meet with the DHS workers, CASA, teachers, and any medical care professionals. During the court hearing, the GAL acts as an advocate for the child and can file motions, call witnesses to testify, cross-examine witnesses, and present independent evidence. At the conclusion of the case, the judge will ask the GAL for a report and/or a recommendation. The GAL informs the judge of their position and what the child wants if the child is of sufficient age. The judge is the one that makes the final decision. Everyone wants the child to return home safely. That is the main goal. Parents who want their children to return home safely will cooperate with the guardian ad litem, the DHS workers, CASA, and their attorneys to ensure that there is a good outcome.
My name is Sean Overby. I am one of the attorneys in the City of Newport News that assists parents who find themselves in front of the court to deal with matters in the foster care system. My job is to provide you with advice and information so that you understand the process. Oftentimes, you may find yourself here as a result of an emergency removal hearing. You're in front of the court. At that point in time, I will appear with you. At each of your hearings in front of the court concerning your child, I will be present. There will be opportunities for you outside of court to meet with me in my office to discuss the matters as they are pending before the court. The Department of Human Services is responsible in the process for preparing a plan which will make a recommendation to the court as to what services you may be required to perform in order to have your children returned back to you.
The Foster Care Service Plan. The Foster Care Service Plan includes the actions to be achieved by the parents. An example, the court may enter an order that mandates counseling or rehabilitative services. The judge will then ask DHS to follow up on the progress or completion of these services.
The plan will require you to complete several things, anything from employment to housing, to substance abuse treatment to parenting classes. The court is looking for you to complete those things in a timely manner. You need to make sure that you are doing as much as you can within the time period that you are assigned these tasks from the social worker. If you have any questions along the way with regards to visitation or any of the services that you are to complete, your attorney is available to provide you counsel or assistance in completing those goals. Again, I cannot stress to you the importance of completing your services so that the family unit has the best possibility of being reunited.
CASA is an acronym for Court Appointed Special Advocate. There are over 1,000 CASA programs nationwide. The purpose of CASA is to serve as advocates for abused and neglected children that are receiving services through the court. CASA volunteers freely dedicate their time to help ensure positive outcomes for children. The judge appoints a CASA volunteer to serve on a case and to receive a court order that allows access to the child's medical, school, and other records. The volunteer thoroughly investigates and researches your case, including interviews with you, your child, relatives, and neighbors. CASA volunteer acts as a neutral observer and asks for the child's opinion about what they would like their future to look like. They also help to ensure that the court-ordered services are carried out for that child.
We have work coming up.
next couple of weeks.
The CASA worker works with all the professionals in order to help ensure that the needs of the child are met. Before each hearing, the CASA worker prepares a written report for the city attorney, the GAL, and the judge. The report contains facts about the investigation, along with the recommendations that the volunteer believes are in the best interests of the child, and the steps needed to achieve a safe and permanent home. The CASA worker doesn't provide any money, any counseling, transportation, or legal advice. I encourage everyone to fully cooperate with your CASA worker. What happens to the family is very important, but our first priority is your child.
All rise.
I want to thank you again for watching this video today and for taking seriously the rights and responsibilities of yourself and the child and understanding more about a system that has so much importance for you and your family. So the clock is ticking. There are many things that have to be done quickly and on time. If you have any other questions, make sure that you talk to your attorney and are fully informed about what all your rights and responsibilities are so that your child can be safe and in a permanent placement as soon as possible.
The court promises to do their part, and they expect you to work hard to achieve a safe and permanent home for your child.
I am for the child who has been abused, the child who is afraid to go home,
who thinks it's her fault,
who is forced to keep the secret or else.
I am for the child who has been neglected,
the child who does not know where his next meal is coming from,
who must fend for herself and her little sister
alone, the child who has never been to a doctor or a dentist.
I am for the child who was taken away
for her own protection,
the child who is now in foster care, who does not know how long he'll be there,
or who these people are,
or if she should trust them. I am for her.
The child who is in his third,
fourth,
fifth,
sixth foster home this year,
the child who has attended 4 schools in 2 years,
who sits in back of yet another class surrounded by strangers,
believing in his heart that no one
cares. I'm for her. The child who has never been told
that he is loved,
that she is smart, beautiful,
talented,
worthy,
that she is strong,
courageous,
that she is somebody. I am for her.
The child who one day will turn 18 and will be surrendered to the world.
I am for that child.
So I am there for that child.
To listen to her.
To speak for her.
To champion without compromise for what's in his best interest.
Because if I
am there for her, I know she will be half as likely to languish in foster care.
And that much more likely to find a safe, permanent home.
She is the child I am for.
He is the child I am for.
They are the children I am for.
She is the child I am for.
The child I am for is him.
Who am I?
Who am I?
Who am I?
I'm a CASA volunteer.
I am you.
What are you for? You can be an advocate for a child right here in Newport News. Find out how.